So good afternoon. So we are now on the topic types of dissolution. So when a partnership ends, it involves three stages. First is dissolution. So when we say dissolution, it's the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on the business. Partnership is not terminated, but it continues until the winding up of the partnership affairs is completed. So, that's the solution. Change in the relation of the partners. Okay? So, kaya na-dissolve yung partnership is because merong nangyari. Okay? There is something happened. Okay? So, we will know what are the different events if we are going to have or for a dissolution to occur. So next is winding up. So that's the process of settling the business or partnership affairs after dissolution. Okay, so that's winding up. You are now going to settle. So it's more of liquidation. And we have termination. It's the point when all the partnership affairs are completely wound up and finally settled. So it signifies the end of the partnership life. So ganun talaga. Okay? So, after winding up, nata-terminate na and the partnership ends. But, here in this solution, it's only a change in termination. Change in the relation of the partner. So, na-terminate muna yung authority of the partners pero hindi pa siya liquidated. Okay? So, it can until masurpass ng partnership yung um, period of dissolution, they can still continue their business. So that's the dissolution as compared to winding up wherein after winding up, mati-terminate na siya and then no solution, no partnership exists na after. Okay? Okay, so we are on the types of dissolution. And one of the examples of dissolution is extrajudicial dissolution. So this refers to the termination of the partnership existence that is effected outside the course of regular judicial proceedings, meaning without court's intervention. So what causes extrajudicial dissolution? Here are the following. First is if the partnership incurred without violation of the agreement between partners. So, ayan, it could be dissolved through any of the following: by termination of the definite term or particular undertaking specified in the agreement. So, this is a partnership for a fixed period or particular undertaking. So, the moment na matatapos na yung period niya at saka matapos yung specific undertaking ng isang partnership, madidissolve po ang partnership. Okay? So, ayan. Next is the express will of any partner. So among the partners, there is one of the partner who do accordance to his or her will or he is on good faith, gusto niya nang tapusin or gusto niya nang i-dissolve ang partnership. Okay? Ayun. So this is a partnership at will. Next is letter C. By express will of all the partners who have not assigned their interest, charge them for their separate debts, either before or after the termination of any specified term or special or particular undertaking. Now, etong letter C, kung si letter B is express will of any of the partner, etong letter C, express will of all the partners, 'di ba, who have not assigned their interest or capital. Okay? So, charge them for their separate debt. So, before kasi, yan, mabibigay yung capital nila. Syempre, their capital should be adjusted by any profit or losses. Ayan, and any withdrawals. Before yan mabigay kay partner. Okay? Ayan. Next is the Bonafide expulsion of any partner from the business in accordance with the power conferred by the agreement. So, they have the power to do that. Okay? Okay, so if that will happen, it will dissolve the partnership kasi there is the change in relation of the partners. Another is in contravention of the agreement between the partners where the circumstances do not permit a dissolution under any other provisions in this article by the express will of the partner at any time. So here, there is a stipulation and then some of the partners contravened the agreement or violated the agreement. So, it will cause extrajudicial dissolution. Next, by any event which makes it unlawful for business to be carried out on for the members to carry it on the partnership. Okay, so here sa number 3, the event is unlawful. So if that will happen, again, it will dissolve the partnership. Another is loss of specific thing promised by partner before its delivery. Okay, so the moment that we promise to contribute property to the partnership, ayun, we are called debtors of the partnership. So if ever the property is lost before its delivery, okay, the specific thing was lost. So the partnership is dissolved. Another is death of any partner, insolvency of a partner or partnership, and simple interdiction of any partner and decree of court under 1831. Another type of dissolution is judicial dissolution. Ito yung kabaliktaran ng extrajudicial. Okay, so this refers to the termination of the partnership's existence handled by the courts located within the state of the company's incorporation. So a dissolution may be obtained when an attorney or general of the state of the incorporation petitions for it due to a company's failure to comply with the regulation of tax laws, administration, or statutory regulations. So it will happen if there is a court's intervention. So what are the grounds for dissolution by decree of court? So that's under Article 1831. First, when the partner declared insane in any judicial proceeding or shown to be found of unsound mind. So kailangan po ng court's intervention to know if really that partner is insane. Okay, so another is incapacity of a partner to perform his part of the partnership contract. So he is a partner and he has duties and responsibilities to the partnership, but as the time goes by, incapacitated na siya, okay, to perform his part or duty, naglaylo na si partnership. So, ayun, pwede siyang ma-dissolve through court's intervention. Next is partner being guilty of conduct prejudicial to business partnership. May ginawa, okay, si partner that is really, not good to the company or to the partnership. Okay, so if he or she is guilty of any conduct, okay, unethical conduct, then it could be dissolved through judicial dissolution. Another is willful. Okay, but when we say willful, ginusto, and or persistent breach, okay, continuous breach of the partnership agreement, palagi mong sinusuwa yung agreements ninyo, or conduct which make it reasonably impracticable to carry on the partnership with him. So parang all the time you and some of the partners hindi talaga magkasundo, 'di ba? So since partnership is a contract which is consensual, so if there is a will for a persistent breach of the partnership agreement, so parang mawawala ng sense. Okay, so it could be dissolved through court's intervention. Next, business can be only carried at a loss. So despite the efforts that you have done to the partnership, but still your business will still be carried at loss. So you can dissolve it, okay, through judicial dissolution and other circumstances which rendered their dissolution equitable.